Hi, everyone. I am Greg McLawsen. I'm the Affidavit of Support lawyer. I represent plaintiffs in federal litigation to enforce the Affidavit of Support, and I also serve as a consulting expert in family law cases where folks are enforcing the Affidavit of Support in a divorce case. And it's the second of those two things that I was going to talk a little bit about today. So the Affidavit of Support is signed in effectively all family-sponsored immigration cases. That includes cases with a U.S. citizen, a child or parent petitioner, a sibling. But most of the cases that actually get litigated, the cases where somebody's actually going to court and trying to enforce the affidavit, are almost always one spouse, a foreign national spouse, suing a U.S. citizen spouse, or occasionally a lawful permanent resident spouse. Usually it's a citizen. So often, not always, but often in these cases, when the affidavit of support issue comes up, when the plaintiff first realizes that they have claims under this federal contract, the parties are often already enmeshed in a family law dispute, or one is coming down the pipeline pretty fast. So, an early question that folks often ask themselves when they're thinking about enforcing the affidavit is, can I do this in the family law case? Because remember, this is a federal statute that creates the I-864. It comes up within the realm of immigration law, which is federal. So an easy kind of knee-jerk reaction is, well, this is a federal issue, and so it probably needs to be enforced in federal court. That's actually not correct. So the vast majority of family law courts that have addressed the affidavit of support have ultimately determined that it can indeed be enforced in a family law case. And there are a couple different ways that that might be done. But let's talk first of all about why this issue belongs in a state court at all. A couple of different reasons to think about. First of all, the affidavit of support is a contract. Who's it a contract between? It's a contract between the U.S. citizen sponsor who signs the affidavit of support. That's one party. And it's between that person and the U.S. government. U.S. government is the other party. The immigrant, the intending immigrant, the green card holder who gains status based on the affidavit is not actually a party to the contract. That person doesn't sign anything, nor do they assume any obligations under the affidavit of support contract. They're called a third-party beneficiary of the contract, and under the way that contract law works generally in the United States, and also because the statute says this specifically, that person has standing to enforce the affidavit of support. But anyway, it is the affidavit of support, ultimately a contract. Well, what do state court judges do all the time? They deal with contract disputes. If you hire somebody to build you a deck and they don't do it or they mess it up, there's a contract lawsuit, and the state courts deal with that sort of stuff all the time. Yes, without a doubt, the affidavit of support has many terms that are defined by reference to federal law, and it's a bit complicated because of that. Nonetheless, at the end of the day, the affidavit of support is a contract. State courts of general jurisdiction can deal with contract disputes, and they do it all the time. That's bread and butter stuff. And so, for that reason, it's no surprise that state courts have authority to deal with the affidavit of support. That's number one. Number two is, in addition to being a contract, the affidavit of support is also behind this framework of the Immigration and Nationality Act, the federal statute. And that statute specifically includes a cause of action. That's fancy lawyer talk for something that says you can go to court and enforce your rights. So, yeah, that's a federal statute that creates the cause of action. So you might say, well, that means that federal court is the place you have to go to enforce it. But under a procedural doctrine called the presumption of concurrency, that's not true. And a state court can presumptively enforce a federal cause of action unless the federal statute says otherwise. And there's nothing in the Immigration and Nationality Act that says this is a matter exclusively for federal courts. So whether you view it as just a contract, or if you think about the federal statute underneath it, either way, this is something that a state court has authority to deal with, and in fact does all the time. Okay, so I'm talking state court, but we were thinking about family law proceedings, which is in a family law court. Well, family law court is actually typically just a division of the broader Court of General Jurisdiction. So here in Washington State, for example, Superior Court is our Court of General Jurisdiction. And when you go to family court, that's actually just a division of Superior Court. So the family law court has all of the inherent authority of the broader Superior Court, and that includes the general jurisdiction to deal with claims under contract and to entertain a claim under the federal cause of action. So this is all to say that, generally speaking, state courts of general jurisdiction can think about and enforce the Affidavit of Support. Family law courts, being a subdivision of that the Court of General Jurisdiction, have that same authority. Okay, so they have the authority. State courts of general jurisdiction, family law courts in particular, have the authority. What does this mean for somebody who is a foreign national, a green card holder, who's thinking about enforcing the Affidavit of Support? Well, there are a couple of ways they might do that. Number one, which is perhaps the obvious way to think about it, is by using spousal maintenance, also called alimony, as a vehicle. So those two parties are already going to family law court to get the types of orders that you typically get in a divorce case. So you're thinking about property settlement. If there are kids in the picture, you're thinking about custody. And if you are the lower income earner in the couple, you're probably also thinking about spousal maintenance or alimony. Most states that have considered the issue, and this includes California, Illinois, North Carolina, Texas, these states have all determined that you can use a alimony order to enforce the Affidavit of Support. That is great news for an Affidavit of Support claimant, a foreign national who wants to enforce their rights under the affidavit. It's good news because that person is already going through a divorce. They're already expending resources on that process. And so it makes a lot of sense in terms of efficiency if everything can be dealt with under the auspices of that family law case. There are also enforcement mechanisms in many states that make alimony orders easier to enforce. Often the state will step in to help somebody enforce it. So that's all good news. What's the bad news? The bad news is that alimony orders are typically governed by multi-factor statutes, or in some cases it's case law in lieu of a statute. But the point being that a judge in ordering alimony has to consider a lot of different factors. When you look at just the Affidavit of Support itself, it's pretty clear in terms of what the foreign national is entitled to. That's 125% of the federal poverty guideline for whatever period of time is at issue. So if the person is unemployed, 125% of the poverty guideline, that's $1,400 per month. That's what they're entitled to under the affidavit. The reason it gets muddier in family law proceedings is that the state judge will have to also think about the different factors that apply under that state's spousal maintenance law. So that might be the duration of the marriage. It might be the financial ability of the other party to the divorce. And so these additional factors weigh in on what it is appropriate for that judge to order. That tends to limit the recovery of the foreign national claimant in two ways. It limits the duration of the support. So you will see alimony orders based on the Affidavit of Support, which instead of being ordered for the entire duration that's permitted under the affidavit contract, Instead, it will be limited to something that seems more fair to the family law judge in consideration of state court factors. So under the affidavit, the contract terminates only after 5 terminating events, one of which is getting 40 quarters of work. The other is becoming a citizen. None of these are necessarily going to happen. So looking only at the affidavit of support, it would be fair for a family law judge to just say, hey, these are the 5 terminating events under the affidavit of support. Alimony goes on until one of those happens. But what you see is family law judges saying, gosh, I'm looking at this, under Texas precedent or California precedent, and I think it makes more sense to order maintenance for 3 years. Now, sometimes you will see those decisions being overturned on appeal. I can think of this happening in Illinois just recently. We wrote a blog post about that on our website. But you are still, as the claimant, even if you know that you might have a victory fighting it out on appeal, because ultimately on appeal, you're probably going to be able to convince the appellate court that the federal statute supersedes any state court rules, and so you can get that longer duration. But even so, you've still gone through the expense of this long period of time of litigating the family case and then taking it up on appeal. And so that is a concern. It's a major concern that the duration of the alimony order might end up being shorter than what you really ought to be getting under the terms of the affidavit of support. In a similar vein, sometimes you will see the amount of the award being reduced. That tends to be less of a factor, often because the financial factors are weighing very heavily on the side of the I-864 claimant. Usually that's the person who's unemployed or very low income, and so equitable factors might be weighing in terms of what that person should be getting on a monthly basis. Nonetheless, it's clear under the affidavit that person should be getting $1,400 a month. But there might be other considerations that intervene because of state family law considerations that would reduce that amount. So again, duration of support and amount of support both become a little bit muddier in the family court arena because we have this clear affidavit of support contract, but it is viewed through the, I guess I want to say, muddying waters, the complicating waters of spousal alimony statutes or case law. So that's thinking about the affidavit in terms of an alimony order in state court. Another way to approach it in a family court proceeding, again, goes back to the fact that these are courts of general jurisdiction. So then you think about what's called permissive joinder rules. And these are going to vary by state, might even vary by different jurisdictions within a state. But the basic idea is this: when you have the same 2 parties in court, you can generally bring in additional claims between those parties. The rules vary, but basically if it's the same parties to the action, similar facts underlying the claim, a lot of times a court will allow an additional legal claim to be joined. So remember, the affidavit of support in one sense is strictly separate from a divorce action. It's a federal cause of action under the statute. It's a contract. But you got the same parties involved. You got some of the similar facts, because the pertinent facts are in large part going to be about the income of the immigrant, since that determines their damages under the affidavit of support. And so forget about alimony. A different way to bring the affidavit of support into a family court proceeding is to say, we are going to join, judge, this additional breach of contract claim, or view it as a federal statutory claim. We are going to ask your permission to bring this into the divorce proceeding because it's the same parties, it's some of the same facts. We are here anyway. It would be in the interest of judicial efficiency for us to just do this while we're all in the same room together. That's a reasonable way to approach it. Here in Washington State, for example, we have the Marriage of Con case out of Division 2, which says alimony orders do not have to issue based on affidavits of support. However, you could potentially bring in the affidavit of support claim into a family law proceeding on that joinder theory. So you're bringing it into the family law proceeding not by saying, Judge, we think this is the basis for a spousal maintenance order, but because, Judge, you have the authority, if you want, to entertain this additional cause of action. Everybody's here already. Let's do it in the interest of efficiency. The appeal of doing it this second way is that, at least in theory, this should isolate the affidavit of support claim from the polluting influence of the multi-factor alimony rules. So remember that one of the reasons these cases go sideways in family court is because the clarity of the I-864 gets diluted by equitable considerations pertaining to maintenance. But if we think about the affidavit of support as a separate claim, and we are just importing that claim into a family court proceeding because we're there already, we should be back in the world of thinking about the affidavit of support as a clean, standalone cause of action where we don't think about the polluting factors of alimony rules, and we think purely of it in terms of a breach of contract action, and we think about it in terms of the Immigration and Nationality Act terms that govern that claim. So those are two different theories about how you would get the case heard in a family court. Number one is thinking about it as an alimony claim. Number two, which is similar but legally distinct, is bringing the affidavit of support claim into the family law proceeding as a different cause of action, as a breach of contract claim. Both of those have been successfully done. So definitely an option. Another option, and this is beyond the scope of what we'll talk about in depth today, but the way that most of these claims end up getting enforced is as a separate claim in federal court. That is not to say that you can't do it in state court. I'm saying statistically, most of them are done as federal claims. So a final thing to touch on is the issue of, could you maintain that federal claim while you are still in family court proceedings? That's an issue we have actually litigated. I've litigated on behalf of a plaintiff. And just to cover this issue very quickly, the potential challenge is that federal judges are, and they should be, careful not to tread on the sovereignty of states when it comes to family proceedings. Family courts and not federal courts have jurisdiction over family matters, and federal courts are rightly concerned about not stepping on the toes of state courts' ability to manage divorce proceedings. So when you have a case like we did, where a I-864 claimant filed a federal lawsuit while a divorce was going on, the defendant sponsor turned around in federal court and argued, hey, Judge, you can't be involved here because we already have this family court proceeding that's going on. You, the federal court, need to abstain from this matter until we can get things worked out in family court. On its face, that seems like a plausible argument, and it seems like one that might spook a federal court into taking its hands off of jurisdiction in one of these cases. The reason that argument fails, and the reason the plaintiff that we represented prevailed on defending that motion in federal court, is that the federal claim is different. So yes, the parties are in family law proceedings together. Yes, they are arguing over money, generally speaking, over separation of assets. However, the federal claim is distinct. And again, the rules governing that claim are contained in the Affidavit of Support. They are contained in the Immigration and Nationality Act and its implementing regulations, but they don't really depend on anything about the marriage per se. And so the federal judge in that case where this issue came up agreed with us on behalf of the plaintiff, arguing, no, that federal claim can proceed because that is a distinct, separate claim. The plaintiff gets his choice of forum. In that case, it wasn't him. about where he wants to bring the claim. He chose federal court, and it can proceed there, even though the parties are ongoing with their divorce proceeding in state court. So the take-home message. Number one, yes, you can enforce the affidavit in a divorce case, usually in most states. You can do that either via an alimony order, usually in most states, or in the alternative, you could do it in family law court as a contract claim that is joined to the family law proceeding. But either way, you should be able to get a resolution of it if you choose in family law court. Alternatively, you as the affidavit of support plaintiff inarguably also have the option to elect a federal forum to bring your claim in. And you can bring a federal claim, a federal complaint, while your divorce is proceeding. It's your claim. It's a separate claim from that which was necessarily at issue in the family law court. And if you want a federal judge applying federal law to your claim, that's your choice. So all of this is good news for the sponsored immigrants of the world. It is their choice as to which forum they believe is most appropriate to enforce their rights. And at the end of the day, they should be able to vindicate those rights either in a divorce court or in federal court. Ask me any questions in the comments. I will do my best to answer them with citations to authority if we need to, and happy to answer case-specific questions that are not in the comments, but you're welcome to use the message function on our website, soundimmigration.com, to reach me directly. Again, my name is Greg McLawsen. I am the Affidavit of Support lawyer. Thanks for watching, and hope this was helpful for folks.